General Flynn, he sought mandamus action against Judge Sullivan for keeping his case alive after the government asked to be dismissed. And that same court said, you can't use that. That's an emergency motion. That's extraordinary relief. He was facing jail time. Hillary Clinton was facing testimony. They said, oh, you can use it. The other big issue, which we haven't forgotten, is the Clinton email scandal. Oh, I know we're not allowed to talk about Clinton emails. It's too far. It's been too long, right? That's old news. I don't know about you, but I don't think it's old news. I think it's always big news when a senior government official blows up the Freedom of Information Act, engages in what is clearly criminal conduct, the investigation of which has been compromised by the corrupt FBI and Justice Department. Frankly, her emails, now we're finding what we've always been telling you, confirmation that she made up the Russiagate smears to distract and hopefully avoid the consequences of her email games and influence peddling and other things that were uncovered as a result of Judicial Watch uncovering her email scandal. And Judge Royce Lamberth, who is a federal court judge who was handling the Benghazi case that led to the discovery of her emails by Judicial Watch, he was upset that he was being gamed by the State Department, maybe the Justice Department. And appropriately, he thought Hillary Clinton should answer some questions in person under oath about her emails and the Benghazi attack documents, which is what about this case is all about. So what has happened? Hillary Clinton used mandamus action, it's called. You lawyers will know what it is. I'm not a lawyer, but you know what I mean. Meaning she short-circuited the appeals process that normally would be available to a witness who didn't want to testify and went straight to the appellate court. And of course, the appellate court here in the District of Columbia, which is controlled by appointees not of sympathetic to Judicial Watch, to put it charitably, gave her a pass, told her that she didn't need to testify, and allowed her to use mandamus, which is typically only available to parties. She wasn't a party in the traditional sense. She was a witness. Typically, if you don't want to testify, you go into contempt and you appeal it. And not only did they let her out that way, but they said the court has no business asking questions about how this happened. That you could have a senior government official take 60,000 emails away, delete 30,000 of them. You have the agencies lie through their teeth about it and continuing to lie. And the court has no equitable interest in figuring out what went on there. FOIA doesn't allow it. Talk about blowing up FOIA if that's allowed to continue. And so that's why Judicial Watch this week asked the Supreme Court to overturn that terrible appellate court ruling. And I encourage you to read it in terms of how it describes how Hillary Clinton was given special treatment by the court through this mandamus action. Extraordinary relief. Remember, General Flynn, he sought mandamus action against Judge Sullivan for keeping his case alive after the government asked to be dismissed. And that same court said, you can't use that. That's an emergency motion. That's extraordinary relief. He was facing jail time. Hillary Clinton was facing testimony. They said, oh, you can use it. Don't worry. You can use this extraordinary relief that contemporaneously we were denying to General Flynn, who's facing criminal cases. It's outrageous, isn't it? Really outrageous. And we told the Supreme Court about that. So the brief, I don't know, Supreme Court is, only hears a small portion of requests. They're called cert petitions in the informal way. But we put it on record what we thought here and what the court ought to do. We argued that the appellate decision dramatically undermines the Freedom of Information Act. In effect, excuse me, it eliminates any discovery into the actions of agency officials or employees other than FOIA officers walling off from any inquiry officials or employees who may be less than honest with FOIA officers who might seek to conceal agency records from FOIA officers to prevent disclosure to the public. Especially important that this misapplication of long-standing precedent be corrected, because the D.C. Circuit's far-reaching decision will nullify the citizens' right to be informed about what their government is up to. And for all intents and purposes, it will eradicate the district court's role as the enforcement arm of FOIA as Congress intended. And as I said in our release, I'm going to quote myself. It's rather than trying to remember what I said, I'm going to just read what I said because it's probably better than what I can remember. No court should undermine the Freedom of Information Act and the rule of law by giving Hillary Clinton special protection from having to testify about her emails. The Supreme Court should cast politics aside and affirm that Hillary Clinton is not above the law. Is not above the law. So I don't know what's going to happen next. Maybe Hillary Clinton's lawyers will come in and object. And I don't know, the Biden administration is probably going to take the same position as the Trump administration, which right now, the Trump administration, by the way, just about a month or so ago, 2 months ago, was trying to shut down all of our Clinton cases. So what is the Biden administration going to do? Anything worse? I doubt it. So think about that when you hear people praising Bob Barr and the establishment. That's what we were facing from the Justice Department and the State Department. So we'll see what the court does. You can go to our website to read the full brief. I encourage you to read it and share it. And it's also about Benghazi. We're not allowed to talk about Benghazi anymore. Susan Rice is back in the White House, domestic policy advisor. She was involved in Spygate, Obamagate, and Benghazigate. She lied 5 times to on the Sunday morning talk shows about Benghazi being tied to a video as opposed to a terrorist attack, which they all knew from the get-go. And she gets rewarded. So this is how corrupt the city is. You fail, you get rewarded. You commit crimes, you get rewarded. Now, only if you're on the left side of the aisle, of course. But often too on the right. What you would think would bar you from employment in another sector, it's no hurdle here in Washington, D.C.
Thanks for tuning in. Be sure to subscribe to our YouTube channel to catch all the latest news from Judicial Watch.